Starting your own private fund or real estate syndication can be scary, in part because of all of the legal implications. On today's episode, my guest and I will answer common fund legal questions. Next. Putting together a deal, forming a fund, and raising capital can take a lot of effort. And on top of all of the logistical and strategic concerns involved with starting a fund, there are also numerous legal concerns. On today's show, my guest and I will discuss some of the most common fund legal questions. Plus, we're going to take questions from you, our live audience. Welcome to Fund Playbook. This is a show that's all about how to launch and raise capital for your very own private fund or real estate syndication. We go live every Thursday at 3 p.m. Eastern Time, so hit that subscribe button to follow the show. I'm your host, Jimmy Atkinson. Today I'm joined by securities attorney Andrew Doup of Syndication Counsel. Andrew, it's great to see you here. Thanks for joining the show today. How are you?
It's great to see you again too, Jimmy. Thanks for having me. Doing well.
Perfect. Well,
appreciate it's good to be back on the show. At Syndication Counsel, we help entrepreneurs navigate compliance with securities laws to raise investor capital with confidence. So we see a lot of situations, talk to a lot of different people, and so happy to join you here.
Perfect. Well, let's dive in while we wait for some questions to come in from our live audience. I've got a question for you to kick us off, Andrew. What's one of the most common rookie mistakes that you see with people launching their first fund?
So this is going to be, I think, an easy one, but it is not engaging with securities counsel or really with any legal counsel is probably where people find themselves in trouble the most. And, you mentioned one of the ways that people raising investor capital can get into trouble, and that's by regulators. So there are rules that govern who you can raise money from and how much you can raise and when you can raise it and what you can and can't do with that investor money. But if you're raising that money with other partners, for example, there's also a risk of partnership uncertainty as well. And we've seen situations and have had to help clients untangle both of those types of problems. So an ounce of prevention is worth a pound of remedy. If you're thinking about raising a fund or a real estate syndication, you want to be sure that you've got the right advisors on your team to help you navigate those hurdles so that you can focus on the deal, and the execution risk.
Yeah, I think a lot of the problem sometimes is that someone who's putting together a real estate syndication or a real estate fund, maybe they start just raising from friends and family. They don't realize at what point their fund or their syndication rises to the level of a security, and they should be engaging with securities legal counsel, someone like you, maybe earlier than they realize. And now, of course, if you're watching this show, hopefully you're aware of these issues. Maybe we're preaching to the choir. By the way, for those watching the live stream right now, if you're here live with us, if you have a question for me or Andrew, expert securities attorney, please take advantage of this time. You can submit your question using the chat feature, and my guest and I will answer your live questions a little bit later in the show. But Andrew, a few more questions I have for you. When it comes to putting together a fund, there's a lot of different ways to do it, a lot of different ways to skin the cat. And I've heard of a lot of different types of legal structures for forming a fund or the management company. What do you like to do? How do you like to advise clients on what type of entity type they should stick to? Should they form an LLC or a limited partnership, or is there another entity type? How do you like to structure that GP-LP relationship?
Yeah, I'll answer that question, Jimmy, but I want to respond to a comment that you made earlier, and it's confusion about, whether or not your business activity arises to the level of securities regulation. And that's a good, fair question to ask. And the general answer is when you take a dollar from a passive investor. So if you are, raising money from friends and family, it doesn't matter, what your relationship is. If the dollar is passive, then that's where you expose yourself to securities liability risk. And that's where these rules and regulations come into play, because they're designed to protect passive investors. On the topic of choice of entity, My general approach is, let's talk about whether or not you have any co-GPs or other managing partners on your team. And beyond that, let's talk about how or who you're going to raise money from. Are these friends and family, or are you going to cast a net that's wider than that? Do you intend to market and advertise your capital raise, or do you intend to raise capital only from people you already know and have a pre-existing relationship with? And the reason why I ask those questions with all of my clients, on even the same client but on a different raise, is because the answer to those questions is going to depend on what exemption your securities counsel will direct you towards. Because as I mentioned, there are rules that govern who you can raise money from and how much you can raise, in addition to how you use it. But those rules have been in place for a generation now, and so we know how to navigate through them. It's just a matter of identifying the answers to what those questions are, so that we can point you down the right path.
Yeah, well, maybe the question was too broad because your answer was it depends, I think. But let me give you a specific example then. What if I'm raising? What if it's me and two other co-GPs? We're partners in the deal. We're raising capital for a $50 million ground up development deal, let's say. And we're going to be advertising the deal within our own personal networks first, but then we want to go out and raise capital. So, we're going to want to advertise on YouTube, on social media, get on some different platforms, and make what I think a securities attorney like you might refer to as general solicitation. So what type of entity in that case do you think would best fit our fund?
Yeah. So it depends, Jimmy. Tell me about your investors. Are they going to be people that you already know and have a pre-existing substantive relationship with?
Answer that question. I'll say no, not necessarily.
Possible. Okay, so you want to cast the widest net possible.
Yeah.
Right. You want to leverage social media to get the word out about how awesome you think this deal is, and to reach out to any potential investors who have a cash burden in their pocket. I think the next question is, how far do you want to cast that net? Do you intend to cast it across national borders, or do you intend to limit the offering to U.S. based audience? What would you say, Jimmy? What do you have in mind?
I don't know. Going outside of the United States sounds like it's fraught with legal risks that I can't even really put my finger on. But for some reason, I just think I want to stick with just U.S. based investors.
Okay. Well, there are a lot of advantages, to doing that. No language barriers for starters.
Yeah.
But also, you don't have to navigate around foreign securities laws that may also be in play. So that
sounds like way too much trouble for me. I think I made the right decision.
You sure did. Yeah. You want to keep it simple, right? You like this project. You just don't have enough money to do it on your own. So that's why you're going out and raising the money. So my general approach is to start with a limited liability company as a choice of entity when compared to a corporation or to a limited partnership. An LLC is going to provide you and your partners the most flexibility to structure offering terms. It's also going to provide you more discretion on whether or not you want to be super formal and have annual meetings and periodic investor votes, or if you want something more flexible than that. But knowing you, Jimmy, I know you like to have your options available. So in your case, I would probably point you towards a limited liability company as your choice of entity. And if you're casting, the widest net possible, your expectation is probably to raise investor capital from investors across the country, in which case Delaware is typically seen as the national standard among investment partners. And the reason why is because there's a court in Delaware that adjudicates business disputes that doesn't exist in every state. So Delaware Limited Liability Company is the long answer to what should have been a short one.
All right, fantastic. By the way, if you have any questions for Andrew about starting a fund or raising capital for a fund, any legal questions about your fund or real estate syndication, and you're in the live stream right now, please submit your question using the chat feature, and we'll get to those questions. And in fact, we did just get a handful of questions in. This one's from John. Let me see if I can get this on the screen here. Let's see. There we go. It's a little bit small. Let me see if I can make that bigger. There we go. Perfect. All right. So there's a multi-part question. So I'm going to have to flash this on the screen in multi-parts. But John says, hi, Andrew, can you talk about the review of the money set aside in a QOF? So he's referring to a qualified opportunity fund, which is a particular type of investment vehicle for opportunity zone investing. I started my own personal qualified opportunity fund in March 2025, so just a month ago. I understand that I can self-report in June. However, for the end of year one, how does that one work? Who reviews that, and what will they want to look at? And then he also clarifies that my QOF will only have myself 99% and my wife 1% as the partners of the LLC. So he's asking about doing and performing his investment standard test, I believe, or his asset test at the during year one. Is that your understanding there?
Yeah, that's what it sounds like.
Thanks for the question there, John. I'll let you answer that one, Andrew.
Yeah, well, first of all, John, congratulations, because not only are you deferring your taxable gain by organizing your own, what I call a self-directed qualified opportunity fund, but you're also positioning your investment for 100% tax-free upside on the 10th anniversary of your investment. Qualified opportunity funds are governed by about 600 and some odd pages of tax rules. So it can be complicated. So the fact that you're going out and doing this I think it's awesome. I would though caution you that there are a ton of traps for the unwary. So if you don't already have a professional advisor on your team who has experience and expertise with these very specific set of tax rules, then you're going to want to find someone who can be on call for you to field questions like this, because if you get something wrong, it can result in tax penalties that you may not, be expecting. I should probably also, Jimmy, take this as an opportunity to state a disclaimer that anything I say on our Q&A is going to be generally applicable and not specific legal advice. But instead, I would encourage, anyone who asks a question like on the Q&A to seek their own counsel. So that being said, John, in your situation, what I would tell a client is that it depends. You started your own personal qualified opportunity fund in March of 2025. If you also contributed your deferred gain in that same month, then what that means is you set up a bank account in the name of that qualified opportunity fund and then transferred your eligible gain from your personal account into the account of that qualified opportunity fund. And that is how you achieve deferral. Now, you still have John made a comment, for training purposes only. That's right. No, this is a useful exercise. Right. So education in training is what I think what this is all about. So you deferred your gain in March of 2025 in this scenario, and that's hopefully within a 180-day period from when you recognized that capital gain. You would report the deferral on your 2025 annual return. So there's really nothing you would do in June. There is no self-reporting in June that you need to do. Any reports you make to the IRS about your deferral activity and your qualified opportunity fund activity wouldn't happen until you prepare and file your 2025 return.
But he does have to do his twice annual asset test. And I think the first one of those might come in June, but there's nothing to submit in June, I think is your main point, right?
Yeah, that's right. Yep. No reporting action in June. But as you point out, Jimmy, there is this, I mentioned a tax penalty. The tax penalty it arises because of this rule that at least 90% of a qualified opportunity fund's assets must be held in qualified opportunity zone property. And that 90% asset test is measured twice per year, once at year end and then once at mid year. So that's probably what you're referring to, John. And in that case, normally you would think, well, if there's a mid year testing date, then I'm probably going to need to measure whether or not my qualified opportunity fund holds 90% of its assets during that first testing date. But the answer is actually no, because there's an exception to the rule for any contributions that are made within the previous 6 months. You can disregard for purposes of calculating your compliance with that 90% investment standard. So you really don't need to deploy your capital in your QOF until that second asset testing date, which is end of December.
Great answer there. And then when you go to file in 2026 for your 2025 tax year, as the investor, you file Form 8997 with your typically Form 1040 if you're filing as an individual. Or as a married filing jointly, a non-entity, I guess is what I'm trying to say, just as a person, right? And then with the qualified opportunity fund, that fund entity will file Form 8996. Okay, we got a lot of questions coming in, Andrew, so wanted to move along. Actually, this comment here from...
I'll add one more thing, Jimmy.
Yes.
There's this incredible online resource called opportunityzones.com. Just a treasure trove of information about OZ compliance.
That's right. Thanks for that plug there, Andrew. We got this comment in here from Freddie, who says that he'd like to retain your services and starting his own QOF. So if anybody's interested in getting in touch with Andrew, syndicationcouncil.com, I believe, is your website. Is that the best way to reach out to you, Andrew?
Yeah, that's right. You can find us online, syndicationcouncil.com, or you can send me an email directly, andrew@syndicationcouncil.com. We're happy to offer a 30-minute introductory call at no charge to Fund Playbook audience members.
Okay, one follow-up from John here. He says, yes, you are tracking, and yes, I have done the things you've said to do, set up an account and transferred like you said. So it sounds like John's off to the races with that one. We got several more questions coming in here. Let's see. Let's get to this one here from Randall. Randall wants to, his question's getting at the difference between a 506B and a 506C. So his question is, are there substantive differences in language and a subscription agreement between a 506B and a 506C offering? Meaning, can we use our existing 506B sub-agreement for our new 506C offering? That was a great question.
Yeah. The answer is, you're going to hate this answer. The answer is maybe. Maybe for the benefit of the audience, we can touch on the differences between a 506B and 506C offering. The primary difference is that under 506C, which is Jimmy's exempt securities offering, in his example, he wants to be able to market and advertise his offering to a large audience. He wants to cast the widest net possible. And the securities offering exemption that would authorize him to do that from a regulatory perspective is Rule 506C. And it's referred to as accredited investor crowdfunding exemption, as opposed to Rule 506B, which is referred to as a private placement exemption. The difference between the two, again, is that you get to market and advertise your exempt securities offering online. You get to cast that widest net possible on the condition that any purchasers are verified as accredited investors. So under a Rule 506C offering, you can market and advertise online if you wanted to, provided that you take reasonable steps to verify your purchasers are accredited. And we can go into what an accredited investor is. But I know, Jimmy, you had some recent content about that exact topic. So I'll spare the audience here. But more directly to your point, Randall, it's hard to say generally. You would need someone to take a look at your subscription agreement and determine whether or not it's compliant with the Rule 506C exemption. It could be, but it might not be. Again, the key difference is that the issuer must take reasonable steps to verify that the purchaser is accredited, and that sometimes satisfaction of that regulatory requirement is baked into a subscription agreement, but not always.
And I also wonder, is this for the same underlying asset or is this for a new deal entirely? That might be a follow-up question I have. And Andrew, I know it's easy to move from a B to a C for the same underlying investment product, but it's impossible, I think, correct me if I'm wrong, to go from a C to a B. Is that correct?
Yeah, you got it right. Yeah, so if you're raising an equity round and you want to see how it sells first to your network of friends and family, you might organize it in reliance on Rule 506B because you don't need to market and advertise the offering. And then once you've exhausted your friends and family, they're not exhausted while you're offering. But once you have offered to them and they have either participated or declined, you decide you want to cast the wider net. At that point, you can then transition from Rule 506B to Rule 506C. You can begin marketing and advertising your offering, provided that all these other requirements for regulatory compliance with specifically Rule 506C are satisfied. To your point, Jimmy, you can't start.
Randall, sorry to interrupt. Randall did clarify this is for a new fund of his.
Okay.
But yeah, sorry, I cut you off. What were you going to say?
No, so to your point, you can't market and advertise under Rule 506C and then change your mind and decide that you want to limit the offering only to friends and family as a private placement because you've already conditioned the public. So that's a no-go.
Yeah, it's a one-way street. You can go from B to C, but you can't make a U-turn and come back to a B after you've gone the C route. Good answer there, Andrew. Appreciate it. Hey, so one question that I oftentimes get from emerging fund managers, somebody who wants to go out and start raising capital for a deal, is how do I make money off of this? I mean, in addition to the performance of the actual asset, how do I make money as a fund sponsor? I've heard a little bit about management fees or preferred return and carried interest, but I don't know how they all work together. What are some standards that you've seen, Andrew, for fees and promote schedule? And what's the best way, do you think, to align those fee schedules so that you're incentivized alongside the investors?
Yeah, this is a really important question. Generally, my first step is to guide the client on how to not lose money. And what I mean by that is organizing and managing an exempt securities offering is a substantial upfront investment. In my worst case scenario, and I think the worst case scenario for a lot of securities counsel is to put in the time and the effort that's required in order to put this offering document packages, private placement memorandum together, make all the SEC filings, and for there to be no sales. We want to avoid that scenario. And one way we can do that is if the client isn't super confident in making that substantial upfront investment, that's okay. What we might instead recommend is that they start with a term sheet. Use a term sheet to have a discussion with someone you might consider a potential lead investor. And, when you guys are aligned on the terms of the offering, which would include things like how the sponsor or the fund manager would make money, then, that will give you as a sponsor more confidence that if you can sell to someone that like and trust, then you're going to be able to sell to a broader audience as well.
And how detailed, sorry to interrupt, but how detailed does that term sheet need to be? Are we talking about, a 25-page document? Are we talking about a one-page sheet with just very basic terms on it? And how much effort needs to go into drafting one of those?
So we're talking a 1 or 2 page document. Typically we want to keep it simple and simple as possible because it's not a legal contract. It's just merely used to facilitated discussion about, what the sponsor expectations are and what the lead investor's expectations are. The key point being, once you align on those expectations, and they're ready, they give you the green light, then you're going to be in a better position to make that investment into a full set of offering documents, and into the time and effort of the sponsor, for that matter, to make this worthwhile. So to your question, how does the sponsor make it worthwhile? There are, really two categories of what I refer to as economic expectations that a fund sponsor or real estate sponsor can set for themselves. The first one is called a promote or a carried interest. This is, you as the sponsor, you're contributing sweat equity to this investment partnership. In exchange for that sweat equity, you're going to get a share of profits. Pretty straightforward. Those profits aren't earned until the investors get all their money back from the investment that you made for them, or that they made with you. So that is referred to as a promote or a carried interest or profits interest. The other category of economic expectations are fees. And, my general, advice to clients here is, look, is the person contributing sweat equity to this investment partnership? You're probably in a good position to contribute other services as well. If you've got a track record, in this space, if it's real estate, acquisitions or development or renovation, put that expertise to work, but don't do it for free. Offer that service to your partnership in exchange for a fee. And, so long as that fee isn't, for more than what the partnership could obtain from a third party at arm's length, then it's going to be in the interest of the partnership to pay you for that service rather than to pay a third party, because chances are you're going to be able to perform that service at a more competitive rate than a third party. So there are many, types of fees because there are many types of services that you can perform for the benefit of the partnership, depending on your business plan.
We could probably I was going to say, we could probably do an entire episode just on different types of fees and different ways to structure the fees and different types of ways to structure preferred return waterfall as well. I think we could probably put together an entire 30 to 60 minute episode just on that topic alone. But did you have any final thoughts on that?
No. Again, those are just, generally the two ways that I break down sponsor compensation on a private investment fund.
Perfect. Well, I've got a few more questions for you that I'm personally curious about, Andrew. So I'll get to them in a moment. In case you're just joining us, we do this every Thursday. We like to take live questions from our audience. If you have any questions for myself or for my guest today, Andrew Doup, securities attorney at Syndication Counsel, please submit it using the chat feature, and we'll try to get to as many of those questions as we can throughout the course of the show. I want to come back to the Rule 506B and Rule 506C type of offerings. There maybe now don't talk about the differences between the two. I think I've got a fairly good handle on that. I think you discussed that already. But at what point in time do I need to pick one of those, and then how do I actually do the thing that I need to do so the SEC knows what I am? And then I've got a follow-up question about accredited investors in a moment.
Yeah. So when I'm onboarding a new client, we typically ask this question at our introductory call. And that question is, does your investment strategy involve marketing and advertising the offering? And if the answer is maybe, I don't know yet, then I'll ask more questions about what the asset class is or how many investors they expect will participate in the equity round. And then just based on a conversation that we have about where they already are and where they want to go, I might lead them down the path of Rule 506B or Rule 506C. And the reason why we ask that question up front is because that determines the scope of services that we provide. Ideally, if you're having this conversation with legal counsel, then they're taking the time to learn about you and what it is you want to achieve, so that they can explain to you what their deliverables are. and that they can provide you in writing, a list of deliverables and an estimate of legal fees, because you don't want to be in a position where, you're not budgeting for your offering and organizational expenses, because we call it O&O. Those O&O expenses are reimbursable to you out of the equity round. So you want to make sure that you know what those are up front and that you're including them in your equity round so that you can get reimbursed from them, from the investor equity, as soon as possible. And the reason why, investors like that as well is because they want you to get reimbursed so that you can go find the next deal for them. So you want to make sure, between the two options, that you have an idea up front which direction you want to go. But if not, then your advisor is going to be able to help lead you down one path or the other.
And then at what point do I need to pick one? And then how do I actually inform the SEC which one I've selected?
I think the second question is the answer to the first. You inform the SEC, or your counsel will inform the SEC when it makes a regulatory filing that establishes your safe harbor under Regulation D. We literally, we create an account with the SEC, and then we make a filing, and on that filing we check a box that tells the SEC which exemption you're organizing your offering under, 506B, 506C, or something else. When that filing is made, so the filing can be made no later than 15 days from the date of your first sale. Our practice is, why wait? Like, why risk being non-compliant? Let's just do the filing as soon as the client has signed off on the offering documents and knows, for sure, if they're going to do 506B or 506C.
So you would just do it when you first form the fund, but technically you do have up until 15 days after you raise your first dollar of capital to file that Form D, and then with that box that ticks whichever exemption that you're filing for the safe harbor under. Is that right?
Yeah, you got it. Yeah. And again, if you decide you want to pivot from 506B to 506C, you can, but you would need to also amend the SEC filing as well.
That makes sense. Yeah, don't forget to do that. And then, okay, so within both types of rules, Rule 506B or 506C, you're bringing in typically accredited investors only. Now, with a 506C, my understanding is there's no exception to that. All of your investors have to be accredited investors. 506B funds oftentimes internally only accept accredited investors, but there actually is a carve out to have up to 35 non-accredited investors in a 506B offering, if I'm not mistaken. But my question to you is, no matter which one you do, what's the process for ensuring that my investors actually qualify as accredited investors? And what's my burden of proof under each different rule?
Yeah, we spoke about this a little bit, but just to recap, under Rule 506C, the sponsor has a regulatory requirement to take reasonable steps to verify their purchasers are accredited. So what does that mean?
I'm curious, like how do I do that? What methods are acceptable for verifying that? What are reasonable steps?
Yeah. So that's the question. What constitutes a reasonable step? It's not defined, in a rule, but the SEC has provided guidance on what constitutes a reasonable step. Actually, this isn't a rule now, but there are, 3 or 4 ways that you can achieve what's called a safe harbor, reasonable step verification. One is that you review the purchaser's tax returns, pay stubs, financials yourself, and you are the verifier, based on the purchaser providing that information to you. So you make the certification that you've taken, you reviewed X, Y, and Z on this date. The documents were, within 3 months of the date that I completed, this verification, and therefore I can now enjoy this safe harbor that I've satisfied this reasonable steps to verify requirement. What we typically advise our clients to do is to place that burden back on the purchaser so that you're not in a position where you're requesting, sensitive financial information from your investor. But instead, another safe harbor is your investor can provide what's called a third-party verification letter. So the sponsor isn't the one reviewing those financials. Instead, the investor is selecting a third-party professional to do that for you. So what's a third-party professional? Well, there are rules about, what that means as well. It's, 4 types of people. It's a licensed attorney, a CPA, or a registered broker-dealer, or a registered investment advisor are the 4 types of people who can write and provide this third-party verification letter. There is, a new way as well. And Jimmy, you covered this. This is,
breaking news about just a few weeks ago,
securities. Right? Yeah, that's right. In the world of securities regulation, this is breaking news. But the SEC in March published a no action letter, and basically what happened is, the question was asked: if a purchaser invests at least $200,000 and they're an individual investor, well, under the SEC rules, you have to have at least $200,000 in annual income in the current year and in the previous 2 years to be an accredited investor. So if they're investing at least that amount, then can we just make the assumption that they're an accredited investor? And the SEC said yes. They said, yeah, you can take that presumption, and we will, and you can assume that they are an accredited investor because they wrote a check for at least the amount that we require someone to have made an annual income in order to be deemed an accredited investor. So that provides much relief to a lot of sponsors in Rule 506C offerings. It relieves them, of this burden for investors who are placing at least $200,000 as an individual investor. But for anyone investing less than that amount, the same rules apply. Reasonable steps are in play. I think, Jimmy, you also asked a question about 506B. Like, how do we know if our 506B participants are accredited or if they're non-accredited? The answer is we provide a questionnaire. And in this questionnaire, which is typically part of a subscription agreement, we list all of the categories that the SEC says that someone is an accredited investor, and we just simply instruct them to check the box. Let the sponsor know how they satisfy that standard. And under Rule 506B, the sponsor is under no regulatory obligation to take reasonable steps to verify that the questionnaire is accurate. So you can see, in 506B world, less regulatory burden when compared to 506C.
Although the 506C regulatory burden just became a little bit lighter with that no action letter, particularly if you were offering a fund that had a high enough minimum. If you're offering a fund that has a minimum of $25,000 or $50,000, maybe it doesn't apply so much. But if your fund's minimum is already $200K or more, then I think your regulatory burden has been lightened substantially with that no action letter, that news breaking from last month. We had an episode on that we released here on Fund Playbook YouTube channel just a few weeks ago. I think the day or the week it went live. So wanted to get to this next question here, Andrew. And I know we're running out of time, so we'll cut you loose soon. But question here from Joe. And Joe, great to see you here. Joe and I just had a call a few days ago. I just met him, great guy, and he's doing some OZ work and has a question for us, Andrew. What is the substantial upfront investment approximately, and follow up, to set up a QOF? So he's also asking about a qualified opportunity fund. We had another commenter, John, asking about qualified opportunity fund, which is a special type of entity, tax advantage entity for investing in federal opportunity zones all over the country. Andrew, what do you think is an appropriate budget for somebody who's setting up a qualified opportunity fund?
Yeah. Just one more thought, Jimmy, on the non-accredited investor participation.
Yes.
So if the sponsor is allowing non-accredited investors under Rule 506B, same process. The investor questionnaire would have a box they would check that, where they make a rep and warranty that they are, sophisticated and, can bear the risk of a complete loss, et cetera. But there are additional disclosure rules that would apply to an offering if they are taking money from non-accredited investors. So I just want to put that one out there.
Yep.
There is a little bit of a higher regulatory burden in that scenario that
good point.
The sponsors should be aware of.
Good point.
To answer Joe's question, this can range, really depending on the scope of complexity involved with setting up and managing the qualified opportunity fund. Just by way of example, a 2-member qualified opportunity fund, like a husband, spouse, or something similar, can range anywhere between, I've seen $8,000 to $15,000, depending on the complexity. But for a syndicated qualified opportunity fund, it can be, 2 or 3 times that amount.
And that's if somebody's actually using the qualified opportunity fund, not just to fund their own captive deals, but to actually go to the market and raise capital from outside investors. Is that right? You would think probably, I don't know, I'm going to ballpark a few numbers, then you let me know how far off I am or if I'm right on the mark, Andrew. I think probably anywhere between $5,000 to $10,000 just to organize the fund and form it. And then you could definitely spend at least $25,000 or more on your offering documents, which includes your PPM and your subscription agreement as well. So, you might want to budget, maybe in that case, somewhere in the order of $30,000 to $40,000 ballpark, roughly. Did I get that somewhat correct?
Yeah. But again, it depends on the scope.
Sure.
If it's like an opportunity zone real estate syndication, for example, it's going to be on the lower end of that range. But if it's a multi-asset private OZ fund, then it's going to be on the higher end of that range, with a lot of variation in between, depending on what terms you're offering to your investors.
Good, Joe. Hopefully that answers your question, but feel free to follow up with me later if you have any other additional questions, or you can submit another one in the chat here anytime.
I did have one prospective new client who let me know. So we did our introductory call, and I provided a written scope of work proposal. And again, I think it's super important that you get that from any legal counsel. But they wrote me back and they thanked me for it. They let me know that they're able to find an attorney who would do it for $200. And it frightened me. But I wish them luck. Yeah,
I would say you're going to get what you pay for in that regard. So $200 to set up a fund, I think is that raises some eyebrows with me at least. So that's an interesting one. Maybe they'll be back in a few months, Andrew. You never know.
Right. Yeah. Like I said, an ounce of prevention is worth a pound of remedy. So ideally you're getting that written scope of work proposal so that you have budgetary certainty in the least.
Yeah, absolutely. Probably the best prevention, by the way, is to have a good deal going in. But second to that, make sure you retain a good securities counsel and you actually do your proper filings and your disclosures, and that can it can be expensive, but it's well worthwhile to protect yourself down the road. One final question I have, and then I don't know if we have any other questions from the audience or not. I'll check before we hop off in a minute here, but we've talked about starting up the fund. We've talked about filing Form D. We've talked about some various aspects of opportunity zone fund management and setup. But if I have my own Reg D offering and I'm off to the races now, everything's filed, everything's formed, I'm raising capital, I'm executing on the deal, what ongoing compliance obligations do I have once the capital raise is closed? Are there any ongoing reporting I need to do to my investors or to the SEC or to any other groups?
Yeah. Typically, there is at a minimum. You're going to want to. So when you have completed your offering, you know what that means is you are now in partnership with a bunch of passive investors, and so we want to continue ensuring that you are protected against any claims that could be made by an unhappy investor, for whatever reason, and that's the reason why we have something called a private placement memorandum. It's to disclose to your investors not only the offering terms, but also the risks that are material to an informed investment decision. And also a subscription agreement, which we've also discussed, which is not only the contract that is used to close on your investor wires, but also to allocate the risk of securities liability away from you as the issuer and onto your investors as informed decision makers. But that doesn't completely mitigate the risk of there being an unhappy investor. For whatever reason, even if you do deliver a return on their investment, they could point to, something in your pitch deck that said that it should be higher and use that as a basis to make a claim for fraud for that matter. And there are plenty of plaintiffs' attorneys that'll take that case up on a contingent fee basis. So we want to protect you against that scenario. And we do that both up front with things like private placement memorandum, SEC filings, subscription agreements, LLC agreements, making sure that all your T's are crossed and your I's are dotted. But also when your raise is fully subscribed and you're now in partnership with private investors, that you're also following corporate compliance. And what I mean by that is the operating agreement is going to authorize you as the manager or the managing partner to do some things without a vote of your investors, but maybe not all, or maybe all, and your investors are 100% non-voting. Even then, we still want to document what decisions you've taken for the benefit of the partnership in your capacity as a manager, so that you've got in your corporate record book, a paper trail of every decision you made, why you made it, and how you determined it as the manager to be in the best interest of the partnership. So if you've got a tight, corporate, compliance track record, then you're going to have a pretty solid defense against any frivolous lawsuits. And beyond that, you're also going to use your corporate record book to help your tax accountants prepare annual partnership returns and K-1s for your partners as well. And this can get tricky if, like in more complex investment partnerships, you're offering discounts to some investors but not all. What that could mean is that even though two people contributed the same amount of money, maybe one partner has a greater ownership interest because you offered them a discount or some other concession in exchange for inducing them to write a larger check than someone else. So your tax accountants are going to look to your corporate record book as well. So that involves, tax compliance. And then when it comes to reporting obligations to your investors, you're going to owe them, the duties that they purchased when they wired their funds. And that's going to be set forth in your LLC agreement. You're going to have a provision with under the advice of counsel, you're going to talk about what reporting obligations you are going to provide to your investors, whether it's annual financials or quarterly summaries, whether those financials are audited or non-audited. Those promises are going to get made in your operating agreement. They're going to get disclosed in your private placement memorandum, and that's what you're that's part of the ownership right that your investment partners are buying into. So you want to make sure that you are fulfilling those obligations after the offering period as well. And then finally, any communications that you make to your investors about, project status or, updates, anything, any responses to any inquiries that your investors have, you're going to be under an obligation to be truthful, right? So you need to be careful because where people get in trouble is if something goes wrong with the project, like maybe you had a bad general contractor. Well, you want to be honest and forthright and candid with your investors about the reasons why you had to terminate your general contractor. Because what you don't want to do is come up with excuses, or other reasons for why the project, isn't performing accordance to your expectations. When it comes down to managing an investment partnership, I tell my clients, really just follow two rules: disclosure and consent. So disclose to your investors, keep them updated on any changes to any of the information that that was included in your PPM. Any deviations, keep them informed. And then finally, if you need their consent to take any action, then get their consent. If things change, deliver the bad news. Don't be afraid to do that, because the worst case scenario is that you try to make up for it in some other way, and you end up digging yourself a deeper hole.
Don't make it worse. Hey, we got one more question in here from Randall, and then I think we'll end it. Randall asks, can a fund sponsor file Form D without using outside counsel? I think technically yes, but there might be some reasons why you would not want to do that. But I'll let you take us home here, Andrew.
Yes, you can. You don't need a law license to file Form D. But you do want to make sure that whoever is filing your Form D has experience and is qualified, I think is the important point.
Very good. All right. Well, we've run out of time. Thank you, everyone. I appreciate everyone who was able to attend live today. And Andrew, thank you for joining me today as well. If you're interested in following up with my guest today, securities attorney Andrew Doup, you can do so by visiting his website, syndicationcounsel.com, or you can email him directly, andrew@syndicationcounsel.com. Did I get that right, Andrew?
You got it. Thanks for having me, Jimmy.
Perfect. Our next episode and live stream will be on YouTube next Thursday at 3 p.m. Eastern Time. You're invited to attend the live stream and ask your questions about starting a fund or real estate syndication so that I can answer your questions in real time. Please be sure to subscribe to us on YouTube. And if you enjoyed today's show, hit that thumbs up button. Helps us out quite a bit. By the way, Fund Playbook is now also available on Apple Podcasts and Spotify. Just search for Fund Playbook on your app or visit fundplaybook.com and click the Apple or Spotify button. Thanks for watching and listening. I'll be back next week with another episode. Thanks again, Andrew.